All right, if we could get back to our seats, we can get going on the next presentation. All right, it's 9:45. If we could make our way back. All right, by way of announcements, we do have the certificate of participation for water managers. Julie will be placing them back by the coffee. If you need to fill one of these out, please do so, and then provide that to Julie. We could always get you a copy if you need that. Our state association keeps all of the certificates that we receive, and so we do have a record of it if we ever need to report to the legislature. They're back by Julie's bringing them back to the. Yep. Our next presenter is Cale Van Bruggen. Cale is a shareholder at Rinke Noonan Law Firm, which has its primary office located in St. Cloud, Minnesota. He concentrates his practice in water law, agricultural law, and on environment and natural resources. Cale primarily represents clients on regulatory and litigation matters, including NRCS, certified wetland determination, Clean Water Act compliance, wetland banking and mitigation, compliance with U.S. Fish and Wildlife Service waterfall production area easements, and Minnesota's Wetland Conservation Act, public waters, wetlands, and buffers law. He also represents local governments in Minnesota and North Dakota on the establishment, construction, and management of water drainage systems and water quality enhancement projects. Cale will be presenting on the topic of being a good neighbor, managing water for the long term. Please help me welcome Cale.
Thanks, everyone. And just want to thank the Water Resource District Association for asking me to speak. When Jack called and said we want you to talk about being a good neighbor when it comes to managing water, I thought, oh boy, that's tough, right? Water's not controversial at all. People don't fight about water. Emotions don't run high when it comes to water. So pretty easy to explain how to be a good neighbor when it comes to water. But I thought, okay, I get called from private landowners who want to do private drainage projects, and my job is to try to reduce risk, overcome hurdles, get them to some level of certainty so that when they spend money on their project, their investment's protected. And I do the same thing for water resource districts, and a lot of that analysis is not any different than I do for private landowners. So I want to go over some of those things, but I kind of want to take a pause at each section and just have a little discussion or some questions that you see in that come up. And there's a lot of talent in this room. There's a lot of information, education. You as water board managers, because you go to these trainings, because you deal with this every day, you have a lot of experience. So this is a higher level type group than just your typical general presentation. So I want to make use of that and as a group kind of learn from the knowledge that's in the room. So Jack already went over my practice. My background, though, is I'm from North Dakota. I grew up in Litchville. My parents are still farming 5 miles south of Litchville. And I think my mother was delighted that I went to law school because, mothers like to brag about their kids. My dad was delighted because I was a really destructive farm kid. I backed the combine into the power pole. I knocked my grandpa's barn off the foundation. He couldn't be happier that I didn't want to stay home and farm. So I'll leave that up to maybe one of my siblings or someone else. But since I couldn't farm, since I wasn't good at being an actual farmer, I decided I'd go to law school and stay connected that way. Okay, so here's an overview of kind of what I want to talk about, and I want to explain how they're connected. I'm going to start on the private side because I think when it comes to water management and being a good neighbor, most projects about water management happen privately. They're not happening at the grand scale that we're all dealing with as water resource districts. There's a lot of stuff happening on the ground. So I want to just start with a basic overview of helping make sure everyone understands what the extent is of private property rights when it comes to drainage, but then also what the limitations are, because there's always someone downstream, there's always someone upstream. And if you're going to be planning a project, you're going to be thinking about being a good neighbor, you have to know what the law allows you to do and what the law doesn't allow you to do. So we're going to start there. Then we're going to move on to just a very brief overview about some land use controls. I'm going to talk about some environmental regulations that are out there, and then I'm going to open it up. If there's specific questions you have about those, we'll go over them, but I just don't have enough time in an hour to go over everything about NRCS wetland mitigation, Fish and Wildlife Service easements, Clean Water Act, but we can certainly talk about that when we come to that time and find out what specifically you want to talk about. Every file that I'm engaged on in water management, I'm walking my clients through an evaluation of what are the benefits of this project versus what are the costs. Okay, you have to do that on assessment drains, and we'll talk about that, but private landowners do that too. Sometimes there are things we do when we're working on a water management project that we do them because they are certain outcomes and there's a benefit there, even if we don't think the law requires us to do it. And so we're going to go through some of those examples. And then again, this is always about reducing liability, reducing risk, and adding value. We want to make sure that what we're doing is increasing the value of our property, of our operation, and we think about that as we start working on water management projects. An effective private water management project requires the cooperation of your neighbor, and sometimes you just can't get that. And so what do we do when we have a neighbor who's uncooperating, but we have a really big need for water management in our watershed? Well, when cooperation cannot be achieved, sometimes you can take that project to the Water Resource District, and you can maybe build the project a little bigger. Maybe you don't have to do that, but you can use the government process in order to force the cooperation or force the hand of someone who's uncooperative for the greater public good. I think most managers will agree a lot of those projects start by a petition from landowners, but sometimes those can also start by the Board of Managers deciding that there's a really big public need here for a management project. And so as a board, we're going to initiate that. So we'll go over some high-level stuff about Water Resource District projects, but then I'm hoping there's enough time at the end that we can just finish that out with a Q&A about what it is you guys want to know more about and maybe share some examples and stories. So this slide here is about 100% of my practice, almost. When a client calls and says, I have this water problem, I'm looking for a resolution, but I don't know how to achieve it, these are the things as a drainage attorney I think about, and I think about them in this order. I start at the top with, like I said in my beginning of my presentation, understanding what those property rights are. What's the extent of what someone's allowed to do on their property with drainage, and what are those limitations? Once we've considered that, then we look at, okay, what are the land use controls? What are the environmental regulations that we have to comply with in order to protect our investment? If it's a client that's a local government unit or it's a private client and they need some extra assistance from a local government unit that can do a project with multiple landowners, then we start looking at our public water management statutes. So in North Dakota, chapters 61-16.1 and 61-21. And then finally, from a federal standpoint, we have to consider those environmental regulations and potential hurdles as well. So let's start with some common property law issues. Just so we're all on the same page, when we're talking about what are your property rights, what can you do and what can you not do with your property, we're talking about surface water. And surface water isn't limited to water that's just on the surface, but the courts and the rules and the regulations are basically talking about water that originates with rainfall or snowmelt. It flows over the top of the land, and then some of it percolates down into the soil. but that still is regulated and treated by the law as surface water. Okay, same set of laws, even though now it's below ground. There's a separate set of laws that relate to groundwater, and that's water that once it percolates through the soil, reaches the aquifer. And that's different, so we're not talking about that. But just out of curiosity, who can tell me in the room what they think on this watershed scale here? Where do you think the cheapest land is if you're going to buy in this watershed? Who has an idea? The lake. Okay. The lake itself or the land next to the lake? Come on, where's the cheapest land? Let's assume that this isn't one of those pristine lakes that we're going to build lake homes on. This is a farming watershed, okay? That's what we're dealing with the most. So where's the cheapest farmland in this watershed? Someone knows this. Underwater. Probably not going to buy that for farming, right? But you're going to go in and you're going to buy land here for an agriculture use. Where's the cheapest land? Closest to the water. Why is that? Because it floods, right? It's our least protected. It's most subject to risk. When you read some of the old cases in South Dakota and Minnesota, some of the states that were draining far before North Dakota was, there's a lot of interesting commentary from judges as they were creating the set of laws related to water, saying, someone's expectation, we like to set laws on what people expect. Someone coming to this watershed and purchasing land, their expectation is that probably the least valuable land for farming is the lowest land in the watershed. Because what? Water runs downhill, right? Now, that sounds obvious, and I don't mean to be so elementary about it, but sometimes we just have to remind ourselves where this foundation of principles comes from. And that's because that's the land, like Jack said, is most subject and prone to flooding. So you're going to invest in planting an expensive crop there, putting some inputs, and then a heavy rainfall comes and that floods out. That's not going to be the most valuable land in the watershed. The most valuable land is going to be the land higher in elevation that's protected and can be farmed. So that's going to come up a couple times. So what kind of disputes are we talking about here? These are the most common phone calls that drainage attorneys get. An upstream landowner has drained, and now the downstream landowner is flooded. So either the upstream landowner is calling because they're being sued, or the downstream landowner is calling because their property is flooding and they need some help. The downstream owner has blocked water and is flooding that upstream owner. That's another common call drainage attorneys get. The upstream owner has impounded water or diverted it away from the downstream owner, and now that downstream owner doesn't have the same access they did. Guess what industry that comes up in a lot? Ranching, right? Someone's relying on that water downstream, and now they don't have access to it for their cattle anymore. Or upstream owners direct water to the downstream owner's artificial drainage system. My land is tiled. I tiled it and designed it for my property, and now my neighbor upstream is dumping his water into my tile system, and it's not working as well as it did before. Can they do that? So all those disputes are answered by what's called in North Dakota the reasonable use doctrine, or the reasonable use rule, as long as there's not some century code provision that pertains to that. So any answer about property rights that isn't already regulated by the century code is going to be answered by that reasonable use doctrine. And part about being a good neighbor, and part of what I try to do in my practice whenever I can, is encourage my clients not to hire me. If you can avoid it, avoid paying your lawyers and paying your engineers to argue about which client is more reasonable. Because there's never certainty there. There's always going to be a question, and some judge is going to decide that, and judges, depending on who they are and what their experience is and what their background is, are going to have different expectations of what reasonable is. So in this presentation, we're going to try to look for ways to avoid having to have that dispute and have that answered by a judge. So here's where we start. This is the case in Minnesota that laid out the factors that make up what drainage or what water diversion is reasonable and what is not. And then this test was adopted by North Dakota. So you can see here there's 4 factors, A through D, and none of them by themselves are determinative. So if you find yourself ending up in court over a dispute over the management of water, all of these factors are going to be addressed, and the court's going to look at all of them in the totality. They're going to start with whether or not there's reasonable necessity for such drainage. Almost always this factor is in favor of the person draining, because you wouldn't spend the investment on the tile or digging the ditch unless you needed to move the water off your land for some purpose, right? To protect a roadway, to protect a farmstead, to improve agriculture production. It's really rare that someone went in and put in a bunch of drain tile just for fun because they didn't like their neighbor, right? We don't see that too often. Second factor is whether or not reasonable care can be taken to avoid unnecessary injury to the land receiving the burden. Meaning, have you effectively evaluated the watershed? Where does the water flow? What are some of the features on the land? What is the land being used for? Can I, for a reasonably same or maybe even just slightly higher cost, run the water through a part of the property that's not being used for farming, like maybe down the road ditch, and get it to a creek that way rather than through someone's cornfield? The courts expect you to look at that. And all these things have to be considered as you're planning and designing your project. The third one is whether the benefit or the utility accruing to the land drained reasonably outweighs the gravity of the harm resulting to the land receiving the burden. This one oftentimes is a simple, how many acres are improved versus how many are flooded. If we had a little bit more time, there's a case that I kind of go through in depth about this, where a landowner upstream gained 40 acres of farmland that was being flooded out about 60 to 70% of the time under normal rainfall events. The drainage helped protect a roadway, and the downstream neighbor lost 2 acres that was along a lake that the water eventually made it to, that they used to be able to farm every year, and now they could never farm because the lake just grew that much. It was a pretty small lake. The district court ruled for the downstream person and said, you have no right to take that 2 acres. And the court in Minnesota, which was before they'd outlined these factors so nicely in this case, said, look, someone who gains 40 acres and protects a public roadway at the expense of 2 acres, that's a huge benefit compared to a pretty small loss. And what did the landowner who bought next to the lake, what should have he expected? That occasionally that might flood, right? So that land was probably cheaper. I know not always. The market doesn't work perfectly every time. But that landowner shouldn't have expected that the the land right next to the lake would be farmed 100% of the year in every circumstance. And then finally, if where it is practicable, your drainage is accomplished by reasonably improving and aiding the normal and natural system of drainage according to its reasonable carrying capacity. So we're looking at which way does the water flow? Are we utilizing the existing ditches and swales that are there? And reasonable carrying capacity. Are the ditches and swales we're using big enough, deep enough to manage the peak flows from our drainage project in order to prevent that damage? And if there's no natural system, then the court will also consider whether there is an artificial system that could be used in order to minimize that damage. And the court will, again, like I said, weigh all those factors. So there's a case in North Dakota, just to kind of illustrate how this reasonable use rule works in relation to our Century Code statutes. It's the Jacobson versus Peterson case. And in this case, there were 2 lakes that were upstream in the watershed, and they had a natural overflow that meandered down through some natural channels. Along that channel were some small basins, some potential small seasonal wetlands, and then eventually those had overflow points and made it down across the plaintiff's property. And so the defendants, the upstream landowners in this case, they dug a ditch from those lakes. They straightened that meandered channel, thereby draining those small wetland areas, and they improved the runoff from their property so they had more consistent control for rainfall events and farming. And in that case, the court looked at both the drainage of the lakes and that improvement of that natural swale and those wetlands separately. And they said, look, the water naturally flowed the way that the landowners drained it. The downstream carrying capacity coming off of that straightened channel and those wetlands had enough capacity that it wasn't spilling out over the banks and flooding defendants' land in a proportion that was way greater than the benefit upstream. But there is a statute at the time that prevented landowners from draining lakes that had a greater than 80-acre watershed. And so the court said you didn't have a permit for draining the lakes. That was illegal. But at the time, the statute did not require a permit for straightening and meandering that channel in the low-lying ground. And so the courts there applied the reasonable use test. And they determined that in this case, under these facts, those upstream landowners were reasonable for that drainage. So they had to either close the drain to the lake or go get a permit, potentially were liable for damages that are attributable to draining the lake, but ultimately were held not liable for the damages coming from meandering that channel. So here are some general principles that we think about when it comes to drainage. You may not collect surface water and divert it from its natural channel to discharge it where it would not otherwise have gone. Now that sentence is probably a little more strict than what the courts might apply. But if I have a client who's draining across a watershed, that's one factor, okay? I care now a lot more about the reasonable carrying capacity downstream. If I have a client who's using a lift pump, sometimes I get phone calls and said, well, they use a lift pump, that's illegal. Well, lift pumps aren't inherently illegal, but if you have to use a lift pump, that's saying something about the elevation of the land, right? It's saying that you're lifting water above an elevation that maybe otherwise would naturally go. That's fine, but I'm gonna be more concerned now about what's downstream and what's the carrying capacity downstream of that lift pump than I would if it was a tile that was gravity outletting or if it was, a surface flow ditch. So you have to weigh each of those factors and consider how they play off of each other. You may drain your land by ditching or tiling and even pumping, although the effect is to accelerate the movement of water and increase that volume of water. It just has to be reasonable. Owners are legally privileged to make a reasonable use of their land, even though the flow of surface waters is altered and causes some harm to others. So keep that in mind. There is a property right attached to that higher in elevation property. Liability only attaches when the harmful interference with the flow becomes unreasonable. So if I walk onto my downstream neighbor's property and they say, Cale, you don't have a right to be there, that's trespass. I can't do that. I'm physically present there. But if I cause water to go there, you might think, well, why is that water not a trespass? If I put water there that never made it there before, that's occupying property. Why is that not trespass? Well, the courts treat that as trespass only if it rises to the level of unreasonable water. And a lot of the discussion on that from the early court cases is just, agriculture is an important industry, water flows downhill. We have to have a test here that works for promoting the reclamation of land, for use for agriculture, and for use for things like building public infrastructure, roadways, highways, those sort of things. And then for reasonableness or unreasonableness, it includes such factors as the amount of harm caused, the foreseeability of the harm, and the purpose or motivation of the action. The courts are going to look at all of those things. So with that, just want to take a pause before we go into some land use issues for questions, comments, stories, disagreements, that sort of thing. Was that news to anybody? Has anybody said, I've never heard that before. I can drain my land across downstream property. That's good. Question? Yeah, very good question. So I know it's being recorded, I'll repeat it. The story is a couple landowners have cooperated to do some drainage with a lift pump. Nothing was documented as far as a drainage easement agreement or any contracts recorded at the county recorder's office that said things like who's responsible for maintenance, who's gonna pay downstream damages, those sort of things. Everything done on a handshake, nothing formally documented. Those landowners now who are harmed due to a lack of maintenance, it sounds like, downstream. Okay, so now he's changed the... Okay, good question. So the situation now is the drain has been closed, landowners are coming to the water board, no one has a contract to say, hey, we signed this contract and recorded it saying you'd keep this open, what's the water board to do? So we are going to, immediately after these slides, so let's just go there now. I want to talk about culverts, so I'll come back to that. But we're going to talk about this, and I have some slides specific to your situation in here about, what's to be done. Before I get into that, in part, this dispute is a private neighbor-to-neighbor dispute. Okay, there are some obligations and there are some rights, and sometimes as water board managers, unfortunately, we just have to say, we want to help you, but this is a private dispute. Okay, or you can say, this is a private dispute. So one option is, maybe lawyer up and figure out what your rights are, what your limitations are, that sort of thing, right? There's another option, which is, as a water board, you can look at what's going on in this watershed. Could this watershed manage from some kind of public project, and maybe is the scope of the issue big enough to warrant spending some taxpayer dollars on studying this and putting together a water management project? So regardless of the private agreements and the contracts, whether they exist or not, you as a water board might be able to help solve the problem by engaging in an assessment drain project and starting to study that. Now, fortunately, that requires some landowner cooperation too. In Minnesota, if a petition gets filed and certain elements are met, the board has to approve the petition. But you all know that in North Dakota, there's some cooperation required from taxpayers, right? You can design a project that might fix that solution, but you need the people who are going to pay for it to affirmatively vote for it and say, yeah, this is good for the watershed. So we'll talk about, some tips and things on how to, think about designing those things, meeting with landowners, getting that public involvement. But if you go to the watershed and the taxpayers who would pay for that project and they say, no, we don't want this, you're potentially stuck, right? Unless you fund that project through some other mechanism, not using special assessment tax. And in that case, you might have to go to them and say, yeah, we're the water board, but we don't control everything related to water. You might need to lawyer up here and figure out what your limitations and rights are as property owners. So how could let's use those landowners as an example. How could the situation they're in right now be avoided, where there's some uncertainty, there's some risk? One of those ways is by drainage agreements. So if you're an upstream landowner and you're confident that your drainage project is reasonable, you don't need a drainage agreement. If you get sued, the judge is going to rule in your favor. But even if you have all the confidence in the world and you called 10 drainage attorneys and they all told you, yep, you're in the right, your drainage project is reasonable, there's still a cost to getting sued. And so drainage agreements, if you can get the cooperation of your neighbor to put them together, are a great way to reduce that liability and that risk. Again, what we're trying to do here is avoid paying attorneys to argue about what's reasonable. It's sometimes just as frustrating to pay attorneys to argue about what the terms in a contract mean, but it's generally a lot less risky than arguing about those 4 factors. It's a lot cleaner, maybe not black and white, but typically a lot cleaner dispute as to whether someone is following a contract or not. So one way we can work around this is drafting drainage agreements, putting our rights, responsibilities, and expectations in writing, and then recording those against the property. Why do these have to be in writing? Because North Dakota, like almost every state, has a statute of frauds that says if you're going to claim a property right or enforce a property interest, that has to be in writing. And that prevents the courts from having people come into court and say, well, Cale said this. Cale promised to keep that ditch open, and then he didn't. What do you think Cale's going to say in court? That's not what I said, right? And what's the judge to do with that? So interests in property have to be in writing for the most part in order to be enforced. And then those easements stay in effect typically for some term that's in the contract. They might be perpetual, and then that means they stay in existence until there's a mutual agreement by all of the landowners to amend or cancel that contract. But in North Dakota, we have a statute that says all easements are limited to a term of 99 years. So as you're looking at easements, keep that in mind going into the future. I did say that there are some exceptions to the statute of frauds, and this might have some application to your case. Now, this is a Minnesota case, but North Dakota drainage law has adopted the Minnesota standard. And so, although it's not exactly precedential, meaning the courts don't have to follow every Minnesota case on drainage, it might be a little persuasive because this case is about reasonable use, and those landowners in your situation now that are fighting over how this water was managed with this ditch have a reasonable use dispute. And so this is a case where historically 2 neighboring landowners got together and on a handshake deal, they built a common drainage improvement to benefit both of their properties. And one contributed labor, one contributed money. Doesn't exactly matter how that breakdown is as long as both are contributing something. It's a different set of facts if one landowner just built it and the other one either objected but didn't do anything about it like sue, or just passively allowed it to happen. That's a little bit separate story. But here, the previous landowners of this property worked together and built this ditch. Thereafter, one of them tried to close that ditch. I think in this case, they replaced it with tile that was insufficient size. And the other landowner who used to benefit from that open ditch was flooded. And they ended up in court. And one side argued, I have some rights to this ditch. And the other side said, no, you don't, because that's an interest in property. Nothing's in writing. That's a statute of frauds issue. You can't claim an interest in keeping the ditch on my side of the property open without that easement agreement. And the court said there's an exception to that statute of frauds whereby if 2 landowners unite in constructing a ditch and a landowner then thereafter or a future owner of that property somehow deprives the other owner of that benefit, then there's an equitable argument here. There's a reasonable argument that says that's not fair. That's unreasonable. And so they forced that landowner to reopen that ditch and restore that benefit to the landowner that whose predecessor had benefited and had contributed to that construction. That was just a fairness exception, okay? I'm not aware of a North Dakota case yet that has applied the same principle, but it draws from the exact same body of law that the original standard in North Dakota comes from. Now, where that doesn't help you is if in your fact situation, rather than someone affirmatively coming and changing the character of the ditch, they just had let that downstream ditch fill in with sediment over time, and eventually the water level was such that cattails could grow, and now it's plugged up and there's no drainage like it was before. Now the downstream people are being flooded out, right? That's a little bit different situation. No one has affirmatively done anything. They've just failed to act. They've just failed to keep that ditch maintained. There's a case in North Dakota from the Barnes County Water Resource District and the landowner, the last name of Buckholz, who tried to say that landowners have an affirmative duty to keep their ditches maintained. And the court said, no, there is no requirement in statute or other law that says you have to keep ditches open for the benefit of your neighbor. Now, if you go and affirmatively do something, that's a different story. But absent some kind of written easement agreement that's recorded against the property, there is no legal duty to keep that ditch maintained. So here's an interesting question. Landowner calls and says, there's a ditch that my grandfather built with the grandfather of my neighbor. We've been using it to benefit our land for years. My neighbor recently put a fence up, put cows in that on his property, and now they walk through that ditch and they've trampled it so much that it no longer drains my land. I now have a big lake on the downstream side of my property. Is that affirmatively doing something? Or is that just a change in land use? I don't have a good answer for that, but that's another example of some uncertainty and some risk that comes along with any drainage analysis, that we always look for ways to try to resolve that cooperatively first before running into a court and see if some judge will first adopt that same analysis that I just went through in this case from North Dakota, and then also extend that to someone putting cattle in a road ditch and causing the ditch to block up that way. So I think that covers easement agreements. Are there any other questions related? Yeah, so the other exceptions to the statute of frauds are let's say if Jack builds a a ditch, and let's just assume we all agree it was an unreasonable volume and speed of water. Pointed at Sean and said, Jack. We'll go with Jack. And I don't object to that, but it is, flooding out my land, and I let that flood out my property for 20 years in North Dakota, 15. This is the narrow practice, but multiple states. So this is where I get hung up. I got to look it up. 20 years in North Dakota. So I let that water flood out my land for 20 years. Jack is using my land as an outlet for 20 years, and I don't object to it. There's an exception to the statute of frauds that says Jack might now have a prescriptive easement against my property to keep using it as his outlet in the same fashion that he's been doing before. And it has to meet some certain elements, and that's, again, sometimes risky litigation, but it's a little bit different set of facts. It's not that we cooperated in that, it's that he just did it. That's the same principle and kind of the same test as adverse possession. You might have heard of adverse possession. I build a driveway on your property and you don't object for 20 years, I maybe now own that property and I can get that title quieted in my name. So some other exemptions, things like that, but they're very fact specific. Almost all of them require a litigation test that's almost certainly unreasonable, or applies some kind of reasonableness standard that is uncertain in its outcome. And so to the extent we can, as drainage attorneys, we try to sit down with our clients and say, okay, you might in principle feel like you're in the right here and they're in the wrong. And trust me, I'm happy to litigate that for $75,000. But if a drainage tile solves your problem for $10,000 and you both can live with that and you can put it into a contract and agree to that, there's a lot of things you can do with that, $60,000 that are a lot more fun than writing a check to your attorney, right? Can't always get that cooperation, but we try and try to avoid, getting into court and having that risk. Practice in Minnesota, North Dakota, and Iowa. Yeah, so good question. In law, there's this concept of precedence, which means the district courts are supposed to follow the decisions of the North Dakota Supreme Court in North Dakota. They set precedents, and that's what the district court judges are to look to. When these first drainage cases came up in North Dakota, there was no precedence yet. And so in those cases, the judges say, okay, this is our first case. What are other states doing? What are other farming states doing? How are they handling this? And in some of the cases even earlier than this case, they talk about how some of the other states are handling this issue. And then they decided, as a case of first impression for North Dakota, we're going to adopt the test that is used by the Minnesota Supreme Court. And in that case, they cited to this Anderson case. And they said, we think that their rule is good rule for judges to use in North Dakota. So, although this case, that Will v. Bowler case, is a Minnesota case, it's a case analyzing the same test that North Dakota Supreme Court adopted. So do they have to follow that test? Absolutely not. Is it persuasive, though? Probably pretty persuasive. Good question. Okay, I want to talk about culverts a little bit. Or any other questions about drainage agreements?
Well, I was just wondering, is it legal or illegal to block like a ditch or a drain?
Is it legal or illegal to block a ditch or a drain? So you have an administrative code process here that applies by statute, and potentially, if that doesn't apply, you have a potential reasonable use claim. But there is a statute in North Dakota law that says it is illegal to obstruct a drain or a ditch. And if you encounter that, you can have that situation addressed administratively by filing a complaint with the County Water Resource District Board. And they will investigate and they will decide whether or not a ditch or water course or drain is being blocked. And if they decide it is, they'll send a notice to the landowner with the block and say, you have to either remove that block or come to our board and show cause why that's not a block and why you should be able to maintain it. And if you don't remove it by a certain date, then we will remove it and then we will assess that cost to your property. So, an administrative remedy. Those administrative remedies are about fixing the problem going forward. They don't do anything for past damages. So, if a landowner lost a bunch of crop because of that block, that landowner might have to bring a litigation claim and go to court in order to be paid back the damages that were suffered. That's separate from, getting the problem fixed. The court can also issue an injunction and fix the block, but generally if there's an administrative process that gets you the same remedy, you have to exhaust that first or go through that first before you can run to court. Good question. Anything else on drainage agreements, private water management? Okay. So just want to talk a little bit about culverts. And I think this is kind of a good build off of some things that Jack was saying about this last legislative session, and I'll make some comments too about that bill. But this is just a piece of property I'm familiar with. It's south of my parents' farm. It's an issue that I've kind of watched growing up, but didn't really pay much attention to until I became a drainage attorney. Now every time I drive by it, it looks different to me, right? As a kid, this was just a cool place to occasionally hunt ducks. But now I look at it and see things a little differently. So, does this have a pointer, Jack? Ah, there. This is some property south of my parents' farm that they farm right here, and we're looking at this area right here. So, when I was a kid and I was too young to actually help on the farm, and I was just riding along, this was cropped in most years. As I grew older and as North Dakota went through a wet cycle in the 90s, this started to grow and become cropped less and less frequently. Now it's hardly ever cropped. Now it's pretty much wet here all the time. So we're talking now about, what's a landowner to do? Someone calls and says, I'm losing this cropland that I used to farm, what should I do about this? Well, if this was being caused by water being obstructed by a private neighbor, we'd be applying that reasonable use test. Is this being caused by something unreasonable that someone's doing downstream or upstream? But in this case, we have a roadway here, and no culverts. There's no culverts in that road whatsoever. It's not providing any drainage. So let's just assume that we all agree that the cause of this area starting to grow wet and turn into wetland is that this roadway is obstructing the natural water course. Okay, it's a little bit different. If it was a private landowner, we'd have a lawsuit, and it would be about trespass, negligence, and nuisance, and the test the courts would apply, despite all those causes of action, would be reasonable use. Because it's a government actor, because it's the road authority, they are taking land for a public purpose. Why is that? Well, in order to have a roadway here for the public to travel on, they are blocking water and causing this land here to flood. So they're taking cropland and turning it into flooded water in order for the public to have a roadway here to travel. That is a taking. We call that inverse condemnation, the government using private property for a public purpose without paying any compensation for holding back this water here, okay? The tests that the courts apply, same test, reasonable use. This only rises to the level of a taking if what they're doing is unreasonable. Now, the government actually, if you want to get down into the weeds, has a little bit stricter standard. They have to be more careful than private landowners. But essentially, if this naturally flooded this way anyway, and the land use characteristics aren't the same, some courts would say that's not a taking, even if you're holding back a little water. But if we go back and look at historical aerial photographs, this is cropped, county highway is built, now it's no longer cropped. So it's drastically changed the characteristic of that land. Problem here is essentially roadways are berms. Okay, the roadway is a dike. It's great, trust me, we need this road. It's a good to have a road there. I'm not mad at the road, but it's not managing water in the way it should. It's effectively a berm that's blocking that water. How many of you use or have heard of the USGS Stream Stats tool? This is one where hopefully in the next couple of years I see a lot more hands. So if you haven't checked this out, not only is it helpful, but it's fun to play around with. If you go to usgs.gov, and this is why you have engineers, because when you hire engineers for your water boards, they are, trust me, doing a lot more professional look and a lot more in-depth look at water management for you than what this tool will do. But if you're trying to assess a problem for yourself, or you're trying to think about a complaint that you've received, this is just a helpful tool to get a very high-level understanding of what's going on in the property. But if you go to usgs.gov they'll have a scrolling banner at the top, and the very first tool will be Stream Stats. And if you click on that, the easiest thing to do is know what the closest town is, type in the town, and it'll take you to that town on a map, and then from that town, find the property that you're investigating or you're looking at. So that's what I did here. I went to Litchfield. I went south of Litchfield 6 miles, and I found this property. And then I clicked on North Dakota so that the website would bring up these blue lines. Now, these are not your blue line water courses like you might hear or might see on an atlas map, but this is based on whatever LiDAR data that the site is pulling from for this area. This is the direction that this tool believes that the water naturally flows. So here's our wetland area. Prior to the roadway being there and interfering with any use or management of that water, water flowed southeast into this property, eventually made its way east along with water coming from here, curves up around, and then we can see here it's getting into a pretty well-defined water course, right? There's some meandering here and stuff, but this is an area never cropped. It's pretty well-defined, always wet area. So I now know that it's likely this was supposed to flow this way, but it's not. That road is blocking it. And if I start to think about, what's the harm that the roadway is causing, well, this is the area that was traditionally cropped under normal rainfall and is now no longer cropped. So what are our options? Well, there's two potential situations here. One is, before the road was built, this was a natural wetland, and it just so happened that the roadway was built directly east and west and directly north and south right on the edge of that wetland. Okay? It wasn't obstructing any kind of stream or water course. It just happened to catch right at the edge of that wetland. Or it could be that this water naturally flowed this way, and now it can't get across that corner, so it's just pooling up here until it percolates or evaporates. How do I know which is the case? Because it's relevant. Well, go back and look at historical aerial imagery, match that up to rainfall data, and can see this was an area that was cropped before the road. Now it's not being cropped. So we're getting a pretty good idea, maybe not perfect, but pretty good idea that it's a lack of a culvert that's impacting that area right there. Even if it was naturally a wetland, eventually most wetlands, not all, but most have an overflow point. So what happens if this wetland's overflow point was this way? Now there's a roadway there and it can't get there. This is going to get bigger and bigger over time. So the solution is go to the road authority and request a culvert as a resolution to that issue and try to get the road authority's cooperation in putting in a culvert there. I'll tell you on this one, they're going to give it. They understand this is a problem. In Lemoore County, they're reacting to this stuff really well. They know that if they just put in a culvert here, guess who's going to be upset? This guy who is not used to, for the last however many years, having water flow across this property. So what's the solution? Well, they can avoid a lot of dispute and concern here by channeling that water in the road ditch, making sure this private driveway culvert is accurate, and then getting it to this pretty regularly flowing channel that has enough capacity to handle what's otherwise natural in the watershed. So I want to encourage the association to maybe take a little bit stronger look at its stance on road crossings and culvert issues. And here's why. Let's say this gets turned into an assessment and drain project, and this culvert is in place. When the engineers go to design the benefit area and the assessment list, guess who they're going to include and who they should include? This landowner right here, right? Because the water can get through the culvert and it can get into that assessment drain. And if we look at elevation and distance to drain and natural conditions, it's likely, not always, but it's likely that we're going to say this land is benefited no different than this land. Other than that, it's just one more section over. But it might be categorized the same level of benefit. But it's rare in what I see that water boards look at, is this culvert sufficiently sized? And should we decrease the assessment on this property because this culvert is undersized and has been there and they're pooling water here? It's unlikely that in North Dakota we look at that level of detail when we determine benefit. But if we're going to tax, assuming that they have the same access as everybody else, now suddenly that culvert being up to code becomes important for the basis of our drain. And it's hard to plan water projects and it's hard to defend assessments if our culverts are undersized and they're not providing that same access. So I would encourage the association to talk about that, consider that. I know it gets really controversial, but keep in mind, if this landowner has a complaint here, well, if you put in this culvert, you're adding too much water. The road authority isn't adding any water. No matter how big that culvert is, you're just allowing water to pass that roadway. If there's an unreasonable quantity of water here, it wasn't created by the road. It was created by someone upstream in the watershed doing an unreasonable drainage improvement. So, unfair, I think, to blame the road authorities to say, well, now that your culvert's there, you're putting an unreasonable amount of water on me. They're just pass-throughs. That water's coming from somewhere else. So I always have to bring up, one really controversial thing. So then I'll pause for questions now, because that might stir up some questions or comments. Yeah, you bet. So good question. The question is, what about, the urban-rural collide, right? When the city land, the urban land starts to collide with the agricultural land. How is that assessed or addressed, or how is that managed? It's the same test, okay? Urban to urban property is a similar test, but a little bit different. But in most cases where typically it's an agricultural landowner downstream of a city development who's claiming that the stormwater system for the development is not managing the water adequately, and now I'm losing crop production, the courts apply that same test. So first they go through the administrative process, have all the permits and the century code provisions been addressed, and since none of them cover damage to property rights, then ultimately it comes down to a reasonable use test. The challenge, or the hard part, that's a little bit different in that situation than neighbor-to-neighbor farming, is who do you sue? Okay, you're on the edge of a city and a 50-unit housing development goes up. Which house is responsible for the damage to your property? And if you don't sue all of them, is your case weakened? Do you sue the developer? Do you have a claim against the zoning authority for not managing the stormwater right? You just have to think of a lot more things in order to get that case resolved as you do otherwise. So generally, again, because there's more work involved, there's more uncertainty involved, those cases that I've had, I'll generally go to the city or the zoning authority or the developer, and if they're still around, if they haven't finished and pulled up and left, and see if we can't work out something cooperatively over the threat of potential litigation if we can't, right? But as far as the extent of property rights and limitations, same test. Question? Yeah. Yeah. Sure. Yeah. Yeah, good comment. And I won't repeat all that because there's a lot going on there. But even as water board managers, when those decisions come to you, occasionally you make decisions that have certainty and have costs, even if you feel like, in principle, this wasn't handled correctly by the landowners that you're trying to settle a dispute with, right? And that's one of the toughest parts of your job, for sure. But trust me, I advise my private clients the same way. You might feel entitled to what you did, or you might feel that what they did is wrong. But sometimes we spend money on things that have a certain outcome, just to remember that farmers are businesses, and every decision they make affects their bottom line, and sometimes that's the right way to go in the long term. I can win a case, but if someone had to pay me $75,000 to do it, it doesn't always feel like a win. And I'd rather my clients be mostly happy and somewhat frustrated than have just won a case but be really frustrated with what they spent. Jerry?
In the case where you said the road is causing all the water, how long was the road there? How many years of drive? And you said you referenced regulating the climate. So, are you blaming the road or are you blaming the climate?
Yeah, well, I'm only 15, so the statute of limitations hasn't run yet in this case, right? No, but good question. How long has the road been there? That's an issue. And there's a little bit of gray area about whether the taking is a permanent taking, where did the government put the water there and then now it's been there for the 20-year period, and so now no takings claim can be made? Or does the water occasionally flood there, and every time it floods, that starts a new 20-year period, okay? In most, but not all, cases with government takings, it's the latter, where the water comes and goes, okay? If the roadway was built and then this area flooded and then it sat that way for 20 years, that landowner probably doesn't have any leverage to go to the road authority and say, you have to either pay me for the value of the property you took or put in a culvert. Now, we'll still go to the road authority anyways and say, can you do the right thing? But if they say no, there's not much leverage at that point. Unless you use, one of the stream crossing study administrative standard, type things. Now remember, the stream crossing study is, okay, you get the road authority to put the culvert in that's the appropriate size. Now for any future damages going forward, if they follow the stream crossing standard and the study from the state engineer, they're protected from this landowner. This landowner cannot sue because the legislature has said, as a trade-off for putting in the culvert to code, we won't let this landowner sue you for damages downstream. And we won't let this landowner sue you upstream if they say the new culvert's still too small. There's some liability protection there. But as far as past harm and damages, that's going to depend on your question, which is about how long has it been there. And then you have to add in what's the character of the damage. Okay, one more question. The question is, do the stream crossing standards always apply? There's a table in the administrative code for township, county, and state highways. And so my answer to that is yes. Any engineers disagree or want to add to that? Sean, Jack? Yeah, Sean is saying the only other type of road might be a private crossing. I don't think that they apply to private crossings. So that would be a pure reasonable test. And the stream crossing standards, originally all we had was the reasonable use test. You had to go to court and have a court decide if the water was being managed reasonably by the road authority. Okay, then the legislature stepped in, as they often do in drainage, and said, let's put into statute, that court test, and let's codify it. And so they put into statute a standard that said, road authorities have to use reasonable engineering principles when designing stream crossings. Well, guess where that ends up? Just back in court arguing about which engineer is more reasonable. So then the legislature said to the state engineer's office and the Department of Transportation, come up with a set of principles and a standard so that, like-minded engineers can sit down, can input the relevant data, and can come to the same conclusions about what the appropriate size culvert is. And as a trade-off, then we'll say, if you follow that standard and you put in the appropriately sized culvert, we'll provide some liability protection for you upstream and downstream for having followed that standard. Are there any road engineers in here who can speak to, when you look at the stream crossing standards, are they looking at what the natural watershed is, or do they take into consideration artificial improvements upstream of that culvert in that watershed? Anyone can speak to that? Dennis? So if someone has drained across the watershed and expanded it, then they would have to consider that. But someone who's just done a tile system within the natural watershed, that wouldn't change the sizing of the culvert. Is that right? Someone else would agree with that? Okay, thank you. And here's the reason I asked, because when this was coming up in Bismarck, this was a big part of the debate. Well, how's it fair to this person downstream? Okay, for the most part, if we follow our reasonable use factors to a T, it doesn't matter what the private improvements are upstream in the watershed. The size of that culvert isn't going to be impacted by that. Okay, it's the size of the culvert is going to be based on what's the natural watershed. And if your complaint is, well, that's going to put harm on me that I don't otherwise naturally have to take on, then the cause of that is the artificial improvements upstream. But in the example of someone tiling across a watershed, adding to a watershed by installing a culvert and running the water a different direction, those are all things that would increase the natural watershed, or the design watershed, maybe we should say, when someone's doing a stream crossing, where that point would be a little bit more valid. So there's a lot of talk during this bill debate about, well, if we allow this, there's no consideration of the impact downstream when the culvert gets upsized.
I have a question. What obligation, let's say the state road, and then they do a major improvement, and they'll design the bridge to specs, or the county designs the bridge to specs, and then unfortunately there's a township road a mile down the road that's obviously ill-equipped to handle whatever the spec needs for the state or the county. Is there anything in state law that gives a little protection for the township? Because in so many of those cases, they are woefully under-designed, and especially when a new state or county project comes in, and the engineer design that to the state specs. And how can townships protect themselves a little bit?
Yeah, so good point. The comment is, if this culvert is brought up to code, but the township road downstream of this county highway is not, when that water eventually gets there, what protection does the township authority have from its culvert being washed out because it's undersized? Or if it doesn't wash out and it pools upstream of that township road, what protection do they have from that landowner who's now damaged? And that was another comment that I think has some validity and needs to be talked about that was raised in Bismarck. If that township brings their culvert up to code, they shouldn't have that pooling problem. And then it will also have the liability protection from the landowner claim. But we all know what the issue is there. Townships just don't have money to bring every culvert in the township up to code. So I talked to a lot of county commissioners who have asked this question, what ideas do you have? I don't think I have the perfect solution, but I said, does your road engineer have an inventory of all the culverts in the county? I bet you some counties do. Some counties definitely don't. I think Grand Forks County does, right? I think they have an inventory of every culvert in the county. But start there. At least get an inventory of where your culverts are. And then really this is a budgeting issue. So you either need to go to the legislature and ask the money for the infrastructure, or budget it over time as you can. And if I'm an attorney and a private landowner is coming to me saying, okay, let's sue the township, their culvert's undersized. But I go to the township and they say, look, we know it's undersized. We know this is the size culvert we need to put in, but we're 3 years out from putting that in. But wait 3 years and we'll have the budget that's in the column that says bring that one up to code next. I'm going to be very discouraging of that landowner from bringing that lawsuit. I say, I know it stinks to wait another 2 years, but they're working on it. They know this is a problem. They're probably fixing an intentional or unintentional issue of people that aren't around anymore, but they're working on it. They have a plan in place to address it. And if you're going to do that, and if you can do that, and if you have the money to do that, then where do you start? At your outlet, right? And you build them up backwards, up towards the upper reaches of the watershed, so that you minimize the number of times that water's hitting that culvert and then pooling. So I know I'm already 5 minutes over, but maybe I'll entertain one more question before I leave the podium. Any final questions?
Let's say two landowners sign an agreement for a drain, and one landowner sells his property. Now, we do not have to put up a building or improve his property. Does that agreement carry to the new landowner?
So the question is, two landowners sign an agreement, and then there's a change of hands, right? A new landowner comes in and wants to do something different with that agreement or different use of the property. Are they obligated to follow that agreement? If the agreement says the magic words of this agreement runs with the land, and it's recorded against the property that is burdened and benefited, so it was at the recorder's office when the new landowner came in and bought the property, the law treats that new landowner as if they had notice of that agreement, whether they actually did or not. The law treats them like they did because it was recorded. And in that case, they're bound by that agreement. They have to follow it, even though they weren't the original signers. So I did not get to some comments I was going to make about assessment drains and project planning and cooperation, but the main points I wanted to make about that I raised at the beginning, which are, sometimes when our constituents and our landowners can't get that private agreement and work things out in this way, then they come to the water board. And sometimes you can help with that by planning an assessment drain project or planning some other sort of project. But most of those, I understand, are funded by special assessments, so they still require the cooperation of people that are going to pay for it. So definitely work with those local landowners. The statute for an assessment drain project, if you just follow the bare minimum of the statute, you're sending out a ballot and you're holding a public hearing on a completed engineer's report before all landowners in the watershed have maybe even had notice of the project and an opportunity to ask questions and comment on it. That's not a best practice. And your engineers will tell you that too. Some things, if you wait until that hearing, come to light when it's too late. The train's already left the station, right? So encourage you to meet early with your project engineer, hold some informational meetings, that are gratuitous, and take that landowner input before the notice goes out of the statutory required public hearing with the ballot. All of those things and that regular engagement on the front end generally help get the best information forward and quell some of those disputes. A really common thing, even when we do that I still hear at public hearings is, why am I just hearing of this now? Well, if we've done the informational meeting, hopefully we can respond to that and say, well, you're not, that's the letter you got 6 months ago. But the more you can do those things to get input ahead of it, the better. So thank you, and I hope to be back here and speaking to you again, and good luck on the rest of your convention.